I'm Anna. I'm a 1L, and I'm a board member with the American Constitution Society, who is hosting this event on racism on death row, the Racial Justice Act before the North Carolina Supreme Court. So just a little bit of background for anybody who doesn't know what this is about. The Racial Justice Act was law in North Carolina until its repeal last year. And basically what it did was in cases where somebody was sentenced to death and it was found that there was racial motivation in their sentencing or in their trial, that sentence would be commuted to life in prison. The one case that has won so far under that act, before it was repealed in June of last year, Robinson v. State, is going in front of the Supreme Court on April 14th, is that right? April 14th, and Don Beskind, one of our professors here, is arguing that case. He's right over there. And some students I know are going to see that on April 14th. So if any of you guys want to do that, drop me an email and we'll see if we can get something together. So today we have 4 really awesome panelists with us, and we're really fortunate to have them all here. We will Jay Ferguson of Thomas Ferguson and Mullins LLP helped represent Marcus Robinson of Robinson v. State in the hearing that led to the overturning of his sentence under the Racial Justice Act. Jim Coleman, I'm sure most of you know him. He's a professor here and is the co-director of the Wrongful Convictions Clinic and director of the Center for Criminal Justice and Professional Responsibility at Duke. Sheila Kenny is the director of the post-conviction litigation at the Center for Death Penalty Litigation here in Durham. And Professor Neil Vidmar is both a professor here and a leading expert on jury behavior in both criminal and civil cases. So to start off, we're going to let Professor Vidmar talk for a couple minutes about the empirical data behind the Racial Justice Act and a little bit of his own work that is sort of related to that, and then we're going to get into the panel discussion. So thank you guys for coming. Let's give our speakers a hand. One more thing, we are being recorded, so if y'all could talk into your mics when you're speaking, that would be fantastic. Thank you.
I'm going to keep my remarks very, very short because I actually want to hear from my colleagues more than from me, but I will tell you that my research on the death penalty and various issues in that, I was telling a student the other day, I published an article, it was my very first law review article was 1974 at Stanford Law Review. I started out with small aspirations, as you can see, and I've been off and on this topic ever since that time, because it was actually public opinion in the death penalty, empirical work, and I published some other articles after that, and so I became especially intrigued when we had the Racial Justice Act, and my colleagues, whom I did not know at the time, but Grosso and O'Brien did such wonderful systematic research that forms the basis of the case that is now going before the Supreme Court. Actually, just being able to demonstrate empirically the extent to which African Americans, mostly African Americans, are excluded in violation basically of the Batson Rule, but certainly with respect to the treatment here in North Carolina. And if I didn't make copies of the Batson cheat sheet, which prosecutors were aware of, in which and it's not only here but elsewhere, how to avoid, most of you are familiar with the Batson Rule about not excluding people, unless you've got a good excuse. When you look at the Batson sheet, it just provides prosecutors with race-neutral explanations, and they've had sessions to train them and so forth. And of course, we all recognize that that is wrong. And the Grosso and O'Brien work, which is done so well, they were actually trained by David Baldus, who did some of the original work on this. But the empirical work goes back a long way on this, back to Maxwell versus Bishop and Furman versus Georgia. But here in North Carolina, it has reached a special point, I think, where we can, that kind of empirical evidence on the basic unfairness and racial discrimination of the death penalty comes to the fore. So I think that I'm always around, so I'll be happy to talk with any of you who want to explore any of that further with me, but I think I should just turn this over to my lawyer colleagues to talk about whatever they have. Jay, we didn't talk about it first, but you were the one that, you mind going first?
I don't mind going.
Go ahead.
There are actually two cases being heard on April 14th. Robinson was the first one, then the second one was a consolidation of three cases for hearing, all out of Cumberland County. And the Racial Justice Act covers various aspects of the death penalty and how race can permeate the process, but particularly in this case, it was all about jury strike decisions. And what we saw from this study from Michigan State, Professors Grosso and O'Brien, is that prosecutors around the state in almost every region of the state strike African Americans 2-to-1 as compared to all other jurors. And I'm talking about jurors who are death qualified, who are post-cause jurors, meaning they are all qualified to sit, they all believe in the death penalty, but yet they are striking African Americans at a disproportionate rate. The hearing, the first hearing, the Racial Justice Act, we could rely solely on statistics. So it was really a statistical trial, if you will. The second hearing, the Racial Justice Act was amended to require some showing in the defendant's individual case, which really changed the tenor of the hearing, because then we dwelt upon a lot of evidence that was particular to that defendant. And my sense of what we see in North Carolina is not that prosecutors will absolutely prohibit African Americans from sitting on the jury, but there's this presumption that they're not really good jurors based on whatever irrational biases they may have. There's a presumption that they're not good. They can overcome that presumption, and I think the best evidence we saw is in one case, in State versus Augustine, the prosecutor had done some jury research because there was a change of venue. And he went and talked to a law enforcement officer and made notes about jurors that he intended to strike or ones that he found not favorable. And there was an African-American female listed on there, but his note said she was okay because she was from a respectable black family. And I think that shows that this particular juror got over that presumption of invalidity because of her race. And so, I don't take any glee talking about this, and I'm not here to say that defense counsel don't also do the same thing. I think that, unfortunately, we make decisions based upon irrational prejudices that we all have, but I think what we're seeing in the death penalty arena is that the best lawyers, the ones that are picking the juries and getting the best results, aren't taking into account race. That's not what matters, because there are African Americans that strongly believe in the death penalty, just as there are white folks. So, but what this case is all about is really what we've seen in North Carolina and what we've seen in Cumberland County. And unfortunately, how we've seen that since 1986, when Batson was decided, how ineffective Batson has been in North Carolina. The Supreme Court in North Carolina has never overturned a case based upon Batson. The Court of Appeals has only given relief in one case, and that's only because the trial judge forgot one of the African American jurors and he didn't give an excuse. So no appellate court in North Carolina has ever said that there was a racially discriminatory jury strike in the last 28 years or 26 years, whatever it is, since Batson, which I think that's quite appalling. I don't think that we could find that record in anywhere else in the country. I may be wrong, but I don't think that to be the case. So what the Racial Justice Act does is it lowers the burden, because in Batson you have to show purposeful discrimination in an individual jury strike, whereas the Racial Justice Act says if race was a significant factor in the exercise of peremptory strikes by prosecutors, and it can be pattern evidence showing over a pattern of time. So it's a lesser burden to prove, because let's face it, you can't directly improve intent. Intent is seldom provable by direct evidence. So we have to rely on circumstantial evidence like these jury notes. But we think that, and the big thing is in Batson also, if you prove purposeful discrimination, you get a new trial. The Racial Justice Act, you get a life sentence without parole. So the reality of the situation is these four defendants that got relief, the relief is that they're going to die in prison. There's no question about that. The only question is, will they live out their natural life, or will the state execute them? And so what our legislature said with the Racial Justice Act is, we want to be especially cautious to make sure race has not permeated the process. And if it has, if race was a significant factor, we're not going to let the execution go forward. So that's what the Racial Justice Act is all about, and that's sort of the findings in a nutshell.
Good afternoon. And I think I was sort of thinking about what Jay was talking about and sort of giving an overview of Racial Justice Act and sort of the two hearings. And I was thinking about one other perspective to add to it, which is I've represented clients in North Carolina since 2001. The first client I represented, who's still serving a death sentence, African-American defendant, and after an argument, unfortunately killed 2 family members, also African-American. He had an all-white jury, and the state struck the African-Americans that were available. And one of the reasons given for striking one of the African-American jurors was she did not show proper respect to the court because she was wearing a Tweety Bird t-shirt. And I was, this is now 13 years ago when I first read that transcript, and to think about this idea of ways to just sort of push off African Americans. They're eligible to serve. She said she was comfortable imposing the death penalty. But for that DA, there was that real feeling reading the transcript of a real discomfort to have someone who's not white with an all-white jury and was sentenced to death for a family homicide. And when I went to go speak to that juror years later, years before the Racial Justice Act, she was horrified to find out that that was the reason given. She said, but I looked around the room. I came, I was there, I was on time. Other people were wearing scrubs or, wearing sort of sweatpants, sweatshirts, and they're going to choose me. And she knew it was because of race. She understood that, and she had no recourse, right? She's gone from that jury selection. Another reason given by that DA for this same juror, because might as well start piling it up, because saying she has a Tweety Bird t-shirt on sounds a little silly, but let's go with some other ones. Another one given was that she was wearing a cross earring. Well, that's really surprising. So wait a minute, she's now, he didn't ask her about religion at all, but he saw that she had a cross earring, and somehow that's a big red flag. I really, really, really doubt that I really bet there was someone else in that jury pool, woman or man, wearing a cross necklace or wearing some other religious jewelry. And I've spoken to her in the past a couple of times, and I've spoken to her again when we did Racial Justice Act investigation out in this county out in Western North Carolina. And what I've always kept with me is, one, I represent these defendants, but talking to jurors who've been excluded, it is painful for them. They went to jury duty, they expected to serve if they were appropriate, and then to find out that maybe you're being pushed out, not because you didn't say something like, I just really can't listen to testimony. You were, as Jay said, you were an appropriate juror, but it's because of race. And so I think of some of those stories of having talked to jurors who've been excluded, and I find it painful to listen to them and know that they feel pain about it as well, that their community and their elected district attorney is excluding them for something other than something legitimate.
Okay, I'll be very brief, and then sort of we can respond to questions that you have, particularly Jay and Sheila. This is a really both important issue, but also a very difficult issue. And resort to race to select a jury in a capital case. For the defendant, obviously, you want a jury that has the ability to empathize with his life, somebody who can find some humanity in a story of a person who's done a really terrible crime. Okay. Okay. And so, you know, when you have juries from which all of the people of color who could have sat on it have been removed, you have all white juries, or you have juries that are, you know, 10 to 1, 10 to 2, or 11 to 1, so that basically the two jurors of color would be overwhelmed by the argument of the, you know, the 11 or the 10 who are present for the death penalty. What's happened is that the defendant has been denied a fair opportunity for mercy. And that's really, I think, what the death penalty comes down to. And I think that's what the Supreme Court thinks that it comes down to. I think in 1986, when the court decided Batson, which was supposed to prohibit prosecutors from using race to exclude people from juries, some of the justices at least thought that that would solve the problem, so that the next year when they decided McCleskey, they thought that the problem had already been solved with Batson. And so while the statistics indicated that there was some risk that race was being used as a factor in capital decisions, the court thought that the risk had not reached a level that was significant enough to make it unconstitutional under the Eighth Amendment. And what it said in that opinion was that, you know, this is a problem that is more appropriate for the state legislatures to deal with. And that's what North Carolina ultimately tried to do with the Racial Justice Act. You know, I think that the result was what most people would have expected. If you look at the compositions of jurors, it's very difficult to make an argument that this is all by chance. And the statistics show that it's not likely by chance. And so now the state has done what the court suggested that it do in 1987, and Don and Jay are going to argue on the 14th whether you know, we're going to whether the results from that will be upheld, or whether we simply go back to what everybody, I think, concedes is a very inadequate approach under Batson.
I will just make a comment and see, and we'll take some questions from the audience about this, because I think you probably have quite a bit and maybe want to know more details about these particular cases. But it did strike me that when you mentioned some of the earlier cases, McCleskey and so forth, that was David Baldus who did the empirical work showing the discrimination there. And there is more recent work, because some of you are not necessarily going to practice in North Carolina, but there is a more recent report that comes out showing the same kinds of behaviors in Alabama, Arkansas, Florida, Georgia, Louisiana, Mississippi, South Carolina, and Tennessee, in terms of the exclusion, escaping the Batson Rule in certain ways. And David Baldus, now deceased, who did some of that original work, has a wonderful article in Pennsylvania Law Review showing that it takes place there, and there's also some research that's showing that it takes place in Ohio. There may be other work, but those are things that I just bring to mind. So I'm always struck with the fact that even if we don't have to call them bigots, the prosecutors in this case, part of the adversary process is such that it results in this kind of racial discrimination. And I think that's worth drawing to your attention, especially if you're going to be practicing elsewhere, because this is a societal problem, not just North Carolina. But of course, we care about it most with North Carolina, because if it's done here and Don and the others manage to do this, it might have repercussions in other states. At least we would hope that it would. And hopefully positive repercussions from our perspective rather than negative ones. Do you guys have other comments you want to make on this?
Why don't we see if they have questions?
Yeah, questions.
I'm kind of curious about the procedural posture of these cases. Are they like a collateral attack on the sentence, or is it a form of appeal?
So The first case, which Don will be arguing, is State versus Marcus Robinson. And at the time that the Racial Justice Act was passed, the statute allowed anyone who was on the row to file a claim within a year. And so it became a new claim and a new motion that was filed. At that time, Marcus Robinson actually was through his post-conviction appeals. The other three, which Jay will be arguing, which is Quintel Augustine, Christina Walters, and Tillman Golphin, were sort of in different procedural postures. Two of them were still in their initial state post-conviction proceedings. But they all were in post-conviction. They had all been sentenced to death, and they had all gone past their direct appeal to the North Carolina Supreme Court.
Yeah,
What's the outcome of the hearings? What do you hope to achieve in these arguments? To just maintain, to sustain the lower courts?
We're just asking that the judgment be affirmed and that their life without parole sentences stand.
And what's the alternative? What happens if you lose?
Interestingly, we think that even if the Supreme Court finds that all of the findings of fact by the trial court were wrong, that the double jeopardy protections prevent all of these defendants from being resentenced because they were actually given life without parole sentences after the hearing. And once you're sentenced to life without parole, the Constitution prohibits you from any greater punishment after that point. So it's our position, and I think very well rooted in the law, that even if the court found that everything that happened below was erroneous, they can't disturb the judgment.
yeah.
What are the statistics, and specifically in the Robinson case, but in the others that are on the defendant's side? And then what level of credence do you think that the justices on the Supreme Court here are going to give to that? I know judges have often been sort of skeptical to, adopt a statistical approach.
Let me answer two ways. There are really two parts to this study. One is what's called an unadjusted study, which is just the raw strike numbers. How many African Americans were struck or how many African Americans were passed. And then there's also an adjusted called a regression model study where they look at various factors that prosecutors around the country and around the state usually give for striking the death penalty. And it showed, for example, if a juror had death penalty reservations, they were likely to get struck. And you would think that that's correct, and it is. That's what the statistics show. My hunch is that the court will be swayed much more with such things as the juror strike notes, where he refers to one juror as a black wino, much more so than the abysmal strike ratios, even though they're so bad. And our Supreme Court...
Say what it is, Jay, the strike ratio.
In Marcus Robinson, I believe it's 3.6.
Yeah.
3.5, meaning that if an African American was 3.5 times more likely to be struck than all other jurors. And actually, Cumberland...
50% of the black jurors were struck in the Robinson case, and only 14% of the white jurors.
And in my three cases, Quintel Augustine...
white, non-black jurors. Yeah.
And in my cases, Mr. Augustine, the prosecutor struck 5 out of 5, so he was tried before an all-white jury. Tillman Golphin, they struck 5 of 7 African-American jurors. And Christina Walters, they struck 10 of 14 African-American jurors. So it's not close. We're not talking about 1.3 or 1.4 ratios you might see in epidemiological studies, like the link between heart disease and smoking. There's a 1.4 ratio. We're talking 3.5. It's astounding. But whether the Supreme Court, my hunch is that the Supreme Court will find much more powerful the differential treatment between white jurors and black jurors, such as the T-shirt. There's a great case involving the prosecutor in one of my cases where she struck an African-American man because of his age, and then the judge said, well, do you understand that that you just passed a white juror who was born on the exact same day? I mean, it's that kind of evidence that I think is very powerful.
So you think they're more likely to decide almost on the basis of anecdotes versus statistics?
I don't know. I think to me, that's just as powerful, if not more so, than the statistics.
I think what's clear is the statistics are not just out in a vacuum. No, they are really supported by the evidence of similarly situated jurors and sort of these notes of sort of these jury strike notes and some other evidence. And one of the other jurors I was thinking about when Jay was talking was another juror in one of the cases for Augustine, Golphin, and Walters, where the prosecutor, she strikes the African-American who's indicated that he had been a victim of a crime on his jury questionnaire. He had had something taken out of his truck while he was not in the truck, and came back after a week of the truck sitting in a parking lot because it was a military facility, and had noticed maybe a CD player or something had been taken. When being questioned, he said to the prosecutor, well, I don't really feel like a victim. And I didn't seek any counseling through beyond the military base, victims counseling. I just it wasn't a big deal. And that's one of the reasons she gives for striking him, because he didn't feel like a victim, and said that he then wouldn't really have the right mindset when we're dealing with homicide victims. It's like such a disconnect. Something being taken from one's truck means that somehow he does not have the ability to understand homicide victims. It just really quite a leap.
I'll add just one other thing. The approach in this case, in these cases, is like the approach in employment discrimination cases, where you're able to use statistical evidence to show that there is a significant disparity in how African-American employees are treated versus non-African-American employees for important decisions, promotions, discipline, and so forth. So you use a combination of both the statistics as well as evidence relating to how individual people have been treated. And I think that's exactly what's happening here, which is that you have the statistics that show that something is going on, and it looks like it correlates with race, and then you have direct evidence of race in these cases. And I think that the combination is what makes it powerful.
I would just add to that as a researcher. I mean, I think it's having been at Duke Law School for 26 years and working with this, whether it's on issues like this or other issues where I've worked as dealing with empirical evidence, the one thing that I've certainly learned that is more persuasive is to have systematic, you can call them anecdotes if you want, but to have systematic qualitative data to back up the statistics. Very much so. The statistics set the ground, and then the anecdotes fill it in, and I think that's what we're talking about. But you can't just have the one, you go about it very systematically in that way, but say, let us show you this, let us show you that. Here's another example, and another example, and another example. And as I read through some of those things, because I've actually submitted 4 amicus briefs and these sorts of things that I've just kind of worked my way through looking at these, I'm just struck by how systematic all of these things actually are. But that's what you need for data. Yeah, let's go here.
So given how systematic the problem seems to be based on this evidence, do any of you think there's anything to recommend keeping the system? I mean, not that we could just snap our fingers and make it go away, but it seems like there's still something, even if the Racial Justice Act were left in place, that is a huge problem, and whether you think there's anything good about the system as it is.
We had a witness testify in the Robinson case who was a judge from Charlotte, and he was a middle-aged guy, looks like me, white, and he never really thought much about race, and he's a district court judge dealing with juvenile cases. And he really got involved in trainings about unconscious bias. And it just transformed him and how he viewed cases. Whereas he would actually, if one party in the case was black and the other one white, in his mind he would reverse it and think to himself, would I make the same decision that way? So and his point was that there are many trainings out there if people are willing to train to discount their own unconscious biases. But unfortunately, what we see is the Conference of District Attorneys who was training not how to get rid of unconscious bias, but how to train around Batson, how to get around Batson. So I don't think we should get rid of the jury system that we have. I love the system, but I think that we can all all do better from some training, and the training is available. And that the reason we put that evidence in is to show the Supreme Court or the trial court that we don't have to throw the baby out with the bathwater. You know, things can be done to make it better.
There is something I can tell you from work that I did years ago. I'm talking about several decades ago. There's something corrupting about the adversary system. I don't mean that because it has so many good features too, but if people, and I was doing some work where I was actually using psychology students, you know, one of these kind of classic studies, but people assigned to one role or another role in as a witness and assigned as a neutral witness, how much it biased the way that they viewed and the way that they testified. And I think the same thing applies when you're getting to the adversary system. The adversary system creates wanting to win. And of course, there are restrictions to that, and we talk about it, but there is a psychological mechanism that I think that subtly biases things. Yeah, way in the back.
How does the fact that the act was repealed affect your arguments, if at all?
I don't think it does. It won't come up in either argument.
When
Can I ask, just given how systemic this problem obviously is and how widespread it is throughout the country, I mean, if it's happening at this stage in the process, it's obviously happening before, and so I understand that this act is focusing on the death penalty stage. But is there any move by the ABA to address this or by law schools to add this to curriculum? Since, I mean, the prosecutors are trained at a law school.
Well, I'm not sure what you mean by to address it. The American Bar Association established in 2000 something called the Death Penalty Moratorium Implementation Task Force. And what it set out to do was to get states to conduct an assessment of how the death penalty was being administered in each jurisdiction that had capital punishment, with the object of identifying places where it was not functioning, so that they could either be reformed or the death penalty could be repealed. The ABA, did not take a position on whether the death penalty should be repealed or not, but said that where there were flaws, the states ought to address them. I think the problem, though, is that you can't fix it. I mean, I just think that this is a problem that can't be fixed because there's no way ultimately to monitor the final decision that the jury has to make, which is, should I sentence this person to life or death? And I think the Supreme Court gave up trying to regulate that aspect of the death penalty, and instead what it focuses on is making sure that a defendant has an opportunity to offer whatever evidence in mitigation he or she has, but then after that leave it up to the jury. The problem, though, is that if you can't regulate how the jury is selected, then that's not going to do very much for a person who who's looking at 12 people who have absolutely nothing in common with him. So my view is that it would be very difficult to fix this, and I'm not sure that any state would want to spend the money that it would take to try to fix it, particularly with the number of capital sentences going down, possibly with the exception of Texas.
Professor Vidmar, you mentioned earlier the developments in other states in this area. And so I'm curious what you all think might occur if you're successful in these cases, particularly what other states may have considered legislation like this or may have been considering repealing legislation like this, or what the other trends around the country are in general.
Well, I don't know about states that might be looking to this to sort of expand and try to add a Racial Justice Act. One other state had something that is somewhat similar to what we had here in North Carolina, which was in Kentucky. But in Kentucky, it was their Racial Justice Act. No one's ever gotten relief under it. Is that correct, Jay? Right? And it was not for. It's the one that we had here in North Carolina was also available to those that were facing trial. It was not just for the population of those on death row. The ones that have gotten relief under it were those that were on death row, but so Kentucky's has been different, but I don't know about any states that are sort of looking to take it on.
Yeah.
I know this is about 4 cases here, but I guess I'm curious on the effect it's going to have on all the other cases that were brought before the repeal of the act. Does it really matter how you win? For instance, if you win on that double jeopardy claim, is that going to actually have a really negative effect on any of the cases that there hasn't been any relief at the trial level?
The double jeopardy I don't think will have any effect. I mean, we certainly believe and are arguing, if it comes up, that, for example, in the second set of cases, that they had a vested right to litigate the original Racial Justice Act. And there's 151 more people out there who we believe has a vested right to litigate the original Racial Justice Act claims. So to the extent that any ruling this court makes sustaining or affirming the lower court's ruling, yes, it could benefit a lot of death row.
Way there in the back.
Do these trends in terms of use of racial discrimination in jury strikes and death penalty cases, do these trends hold across cases and for other non-African American minority defendants?
Go ahead.
Well, there's a very small population, basically, and it's a recent population in North Carolina of any significant minority other than African Americans. So I don't know that the data really goes there.
But I think one thing, and maybe I just misheard you, but so the jury strikes evidence that's sort of was statewide was dealing with whether or not the defendant was white or non-white. So the trends are the same regardless of the race of the defendant. So like certain counties sort of in the mid part of the state where they're Randolph County, which is Asheboro, where there are 10 people currently on death row. It is, or maybe 9 people on death row. I think there's only 1 non-white defendant, but the strike rate they were primarily all white juries. So for that particular DA, whether it was a white defendant or a non-white defendant, all African Americans are getting struck.
Another interesting feature is that across time, it's pretty consistent. Across the state, it's pretty consistent. They were segregated by blocks of time, and nothing seemed to make much difference. It's always 2 to 1. Sometimes it's 4 or 5 times to 1, the strike rate, but I think it's pretty consistently two times or more.
Under this act, are you looking for a 1-to-1 strike ratio? Is that the ultimate goal? And what would be acceptable as a strike ratio to white and non-white jurors?
One of you lawyers?
Well, the state has certainly argued something along the lines of, are we looking for quotas? And that's not what we're looking for. But what there should be is no statistically significant disparity between the two, whatever that figure is. For example, one would think, we know that the prosecutors strike people with death penalty reservations because they're trying to get the death penalty. That makes sense. So when you look just at the people who have death penalty reservations, that should be a 1-to-1 ratio. If that's truly the reason they're giving for striking jurors, it should be a 1-to-1 ratio. There should be no difference. But in fact, what we see is about a 5-to-1 ratio, that they accept 5 times as many white jurors as they do black jurors with death penalty reservations. So there are some times when there should be a 1-to-1 ratio, for example, within those categories. But, we don't pick juries in a vacuum. That's the beauty of regression analysis, is it can control for all the various factors and see if race is still playing a role in the jury strike decision.
Yeah, let's go here.
Can you all talk a little bit about the reaction of prosecutors to the Racial Justice Act and the statistics, and also if there have been efforts by lawyers and judges to sort of perform a self-regulating function, as in, we have this legislation, but why are not more lawyers and judges saying this is unacceptable, we recognize it's going on, and this is how we should address it?
Jay, you talk.
Well, the prosecutors are not happy. And I think, unfortunately, I don't see that there's any movement to actually study these numbers. To this Grosso and O'Brien study, Neil Vidmore mentioned the Pennsylvania study. It was sort of modeled after the Pennsylvania study. But the great thing about our study is that, it's much more accurate because we have race information available for all but 7 out of 7,000 jurors, because the North Carolina Board of Elections, for example, list people's race. So we have a complete and full data set. It's a great study. If somebody was really worried about it and looked at the study, there should be some self-reflection. And I think there are some that are concerned, but prosecutors by and large just say, look, they're just talking numbers. We don't take race into effect. I mean, this prosecutor who wrote those jury strike notes about she's okay because she's from a respectable black family says, I never take race into account. I mean, that's just not valid on his face, faced with the notes that he has. A prosecutor who says, I never used this Batson cheat sheet. I've never seen it. I didn't attend the training that the Conference of District Attorneys put on. She tested, but the state bar record shows she was there. We've got her reading verbatim from that Batson cheat sheet, verbatim.
One of the
they just don't care.
I think one of the things that Neil has done in some of the briefs that he's written to try to kind of blunt the effect of this on prosecutors is to acknowledge that some of this may be implicit bias, that these are not just racists who are doing this, that these are folks who are who have, as a result of culture or whatever, are making decisions without knowing that race is influencing them. But I think that it's hard to convince a prosecutor that that you're not calling him or her a racist when you say that they violated the Racial Justice Act, that's I think that's just human nature. The other thing that happens in this case is that the prosecutors are sort of belittling the idea that most people on death row filed claims under the Racial Justice Act, saying that how could it possibly be where the victim is white and the defendant is white that there's a Racial Justice Act claim even relating to jury service. The implication, in fact, one prosecutor said, the implication is that black people don't have an interest in serving on juries unless civil rights or race is somehow an issue. And I think that's part of the fundamental problem also in this, is that, they look at it as a kind of a, this is about, whether or not we're discriminating against black people in the decisions as opposed to whether or not we're excluding people from participating in the government.
One thing I just want to add to that is I think when you're sort of asking about attorneys and are they sort of trying to, be sort of more self-policing, I guess. When I was doing some investigation back when the Racial Justice Act first passed, I was going out to some counties in the mid part of the state. And these are defense attorneys, but they had been practicing in their community for a very long time. And 4 or 5 of them had said to me, and they'd all done most of the death penalty trials in that county, had said, well, I don't think he's racist. He just is much more comfortable with people that he knows. Well, okay, well, that's white. And so it led to all white juries, but they also felt, as defense attorneys, they had grown up in this community with this district attorney. They had gone to the same restaurants, same schools, whatever. And so there was that sense of having to really sort of explain, well, okay, but if the way that plays out, if you're only comfortable with whites, is that means all the African Americans are off that jury, and whether or not it's sort of what you would call racism, race plays a significant factor in the selection of that jury. And so really trying to help defense attorneys also understand this idea of the subtlety of it and unconscious racism.
Yeah, and just think about it. If somebody called you a racist, how you would respond to that. Well, it didn't happen, and I've spent some time talking to several prosecutors. They are offended by the fact that However, even if the data were to show that, but not me. And I think that that's just one of those reactions that people have. And they get very defensive about it. And a couple of them are now my friends. But every time I bring up because from other work I'm doing, but every time you bring up the Racial Justice Act, the steam starts coming out of their ears, or, they keep it down. So there really is a personal view that somehow I'm a professional person who's doing the best job, and you're accusing me of being a racist. And I think that when you think about these terms, you need to think about this notion of implicit bias, which I think has had more of an impact, and I hope it would have even still more. Yeah.
About that. So you seem to suggest that, if it's implicit bias or it's overt racism, that seems obviously wrong. But what happens if the prosecutor's making the conscious decision to say, we actually think that we will get bad jurors if we take more black people than white people because they're more likely to lead to an acquittal or not impose the death penalty? The same, either because the individual juror would be against it or because a non-all-white jury would be less likely to impose the death penalty. Is that something that, the data suggests is the case? Are the prosecutors wrong to believe that? Have there been studies where you've looked at the willingness of a non-white jury versus an all-white jury to impose the death penalty?
Well, even if you accept that that's true, let's assume that that's true. That wouldn't describe every African-American juror. And the problem here is stereotyping, which is there are so many things that are true about groups when you look at a survey, but they don't tell you anything about an individual person, and jury selection is about individual people. And so if you're operating under that principle and just painting with a broad brush, then what are you doing in terms of citizens' rights to be on the jury?
And that's the whole point of the voir dire, is to try to identify those factors that might make an individual juror unfair. And as Jay and Don and Sheila have said, you have situations where they will exclude an African-American juror on a ground that applies to, white jurors that they've just seated. So, it's not about, it's about the individual when we're talking about jury selection, not about sort of group characteristics.
And I do think that there are tactical decisions made like that. And in fact, there was a Wake County prosecutor who testified, not in this hearing, but previously, that when he picked juries, he did take race into consideration for a tactical advantage, not because of any racial animus. We are not alleging any racial bigotry, racial animus, but I do believe there are purposeful tactical decisions made.
Right.
So I understand the answer to that question, but I was wondering if in these specific cases, whether that are coming before the court or in other Racial Justice Act cases, if I guess the state has done any research or studies to see if interviewing other prospective jurors, if the verdict would have been any different, and if the verdict would have been the same, if the state could use that at all in terms of their arguments next week, if the outcome would have been the same.
Not in this litigation, because the harm is at the moment the strike decision is made, not the result in the trial, because that citizens' rights have been violated. Now, I know Professor Vidmar has done research on, jury composition and numbers and so forth, but that will not come up in this litigation. In fact, the state has conceded that the final jury composition doesn't matter because the harm is done at the strike decision.
I'm struggling with the idea that the harm is to the individual who is struck, that person's right that person is the victim, not the defendant, but the defendant is the party in all of this litigation. Can you go into that a little bit more?
Well, the court has held that the only effective way to enforce the rights of the jurors is through the litigation brought by the defendant. But the defendant is also affected by this. For example, I think a defendant, who's being tried by a jury from which all African Americans have been excluded, loses the benefit of that experience. There are, jurors bring their experiences to cases, and they're supposed to rely on that. When you exclude people because, you think they might be skeptical of the police, well, you won't the defendant wants people on a jury who are not going to just automatically accept that a police officer's testimony is truthful. Somebody who's going to actually subject it to examination. So, sanitizing a jury in that way affects the defendant as well as the citizen who's denied an opportunity to participate in, an important aspect of government.
And given the fact that the harm is supposedly to the juror and then by extension to the defendant, I know that in your crim class we talked a little bit about the fact that white defendants have also attempted to invoke the Racial Justice Act. How do we reconcile that with the idea that you need racial justice? Because if we're talking about jurors being struck on the basis of their race, the white defendant would presumably then have a jury of his or her peers.
Well, but that doesn't necessarily mean that the jury is all white. I mean, it means that you have a jury that has shared some of the experiences that are going to be relevant to decide the case. So in some cases, a peer might be an African American who's lived in poverty, or an African American who's going to a high school and knows about the police officers who patrol there, those kinds of things.
In that regard, are we making some assumptions about the experiences of certain communities?
No, we're just saying that if you do it on the basis of stereotypes, then you are excluding whatever it is that an individual would have brought to the jury. And that's the basis on which juries are to be selected, on the basis of the individual, not on the basis of what you think about a group.
I will make just one more comment. Don't forget that what we're dealing with here, and this is the statistician coming out a little bit here, is we're dealing with juries that have a jury pool in which a large group of people have already been excluded in these death penalty cases because they have reservations against the death penalty. Okay? And it does turn out statistically that African Americans, and I'm not surprised by these findings, are more likely to oppose the death penalty than are whites. Okay? So what we're dealing with is a truncated sample in the first place, and then you make the next step so it cuts them down even more.
If the purpose of selecting a jury is to pick a cross-section of the community where everyone brings their own individual set of experiences to the table, why even have peremptory challenges at all, where you can exclude anyone just because of the experiences you think they may have had?
I think we're out of time.
So some people have proposed that. Either you limit a prosecutor to only challenges for cause, or you eliminate peremptory challenges on both sides. I'm not sure defense lawyers would go for that. Certainly not eliminating them on both sides. So we have to try to deal with the problem unless the prosecutors would give it up.
And in federal court, that's almost what happens. You give a list of questions to the judge says, can you be fair? Do you know the defendant? Okay, we've got a panel. Yeah. You can pick a jury in 30 minutes sometimes in federal court.
Oh, we have lots more, but...
All right, so it looks like we're out of time. Thank you guys so much for coming. Give our speakers a hand because they're fantastic. And also thank you to Don Beskin for his wisdom.